Well, the case was already pending. This is a case that we had filed a First Amendment retaliation claim against the health inspector who came and inspected the restaurant following their Facebook post the day after the mask mandate was originally issued. And they had expressed their protected speech on Facebook that they just didn't believe in it. They weren't going to force anybody to do anything. They were going to allow them to make their own choices. And they suffered retaliation, as we allege, in response to that. So we had already filed that suit, and at the time we filed it, we had also sued the governor and to seek a declaration that the mask mandate was unconstitutional and unenforceable. Also challenged the stay-at-home order itself, which is still in effect, by the way. Now, on Friday the 13th, as we probably all know at this point, the governor had gotten on his live stream press conference and announced that he was issuing a increased, more harsh mask mandate, and that he was going to have it enforced by arrests, and that he was directing not only law enforcement to arrest violators of the mask mandate, but also to that business owners and operators could be arrested for not enforcing the mask mandate. So that caused a lot of outrage and really strengthened the opposition to, this sort of COVID tyranny, as I would call it. And we already had this case pending, so I went ahead and filed an emergency motion for a restraining order and preliminary injunction. I filed it on Monday, so he had made his comments on Friday. And about the same time, the governor sort of backpedaled and started to back down, and then the attorney general came out and kind of supported our position on it. But I had already filed the motion, so by the time we got into court very, very quickly. That's very quick to get into court in response to something like that, but it's because it was pending, and then the federal court gave us a very quick hearing date, and we actually had one of the rare in-person, non-internet court appearances yesterday in federal court, and we had a really great hearing. I mean, it was a 2-hour hearing. That's a long time to kind of talk back and forth about these sort of issues. So I mean, we discussed it in depth, and I think that the federal court joined a lot of other federal courts around the country, and really deferring to a state governor and not wanting to get involved in state law issues, and that is our strongest claim against these mask mandates is the state law issue of violation of separation of powers. And while I think the court could go there, because there was a court in Pennsylvania that did, in the Western District of Pennsylvania, that this court obviously didn't see things the way I do, but did hold that it would have been different, I think, if the governor actually did enforce that order. And to everyone's knowledge, in court yesterday, there had been no arrests, and the governor had sort of backpedaled. And I think had there been arrests, that would have been a different court hearing. I'm glad there weren't arrests, and I hope that there aren't arrests. But we didn't know that when we filed the motion. So we were there first because it was already pending. But I think the strong challenge that is going to happen, and that we're gonna make happen, is going to be a state court challenge, because this is really a dispute of state law. Because regardless of what the emergency powers statute says in West Virginia, it's still a statute. If it violates the Constitution wins. And I think there's a clear case that it does violate the Constitution. And I mean, I can explain that. I've explained it many times. And but we're going to do it again and describe it in state court and see what happens. Well, you can actually go and look up, if you're interested in understanding what the authority is here, look up the governor's executive orders. You can find them on the governor's website. You can find them on the Secretary of State's website. And so you read in those executive orders the foundation sentences, the paragraphs that it starts out with, describing what powers the governor has that they're about to issue. And the same sentence that they put in all these executive orders is from West Virginia Code 15-56C6. And that is, quote, to control ingress and egress to and from a disaster area or an area where large-scale threat exists, the movement of persons within the area, and the occupancy of premises therein. So that's the sentence the governor relies on in all these executive orders. And that's basically saying just controlling people going in and out of a disaster area or inhabiting some sort of premises or structure inside that disaster area. So it's quite a stretch to take that and just declare the entire state a disaster area and then logically claim that you can control anyone's movement or occupancy of any premises in the entire state because it's a disaster area. That is actually what the governor has relied on these past 9 months. But again, that's just a statute. So then if you turn to the West Virginia Constitution, which is the ultimate authority, it controls, absolutely, undisputedly. It says that there's to be a separation of powers between the branches of government, the judicial, the legislative, and the executive, and no one branch can exercise the powers of the other. Therefore, the executive cannot be both the executive and the legislative. Only the legislative can make laws. And the governor has taken that sentence and interpreted it to mean that he can make any laws in the state that he wants to because it's an emergency. But the Constitution says otherwise. It's very simply written, and then it also says that it always applies. It will never be suspended. The West Virginia Constitution says that even in a time of war, it won't be suspended, neither the West Virginia Constitution nor the federal Constitution. Even under a plea of necessity, and is the words it actually uses. So there's no pandemic, no emergency can be severe enough to suspend any provision, not a single provision in the Constitution. So it says that the governor can't make laws, it can't exercise the powers of the legislature. To the extent that the governor has tried to do that, it's just very simply unconstitutional under separation of powers doctrine of the state constitution. So that's the strongest claim, and the federal court wasn't allowed to go into that, unfortunately. But the state courts, that's their job to go into that, and they haven't yet. So this is something that needs to be decided regardless of whether the legislature comes in and clarifies this emergency power statute. Regardless of that, we need to resolve what I believe is a state law constitutional crisis. Well, the Constitution has an answer to that as well, and I'll preface my answer to that by saying that I think if you're talking about an emergency that usually is very temporary, days or even weeks or even 14 days, and the governor takes action that he thinks is necessary at the time, the courts are going to give deference to that. But I mean, let's look at reality here. It's been 9 months, and so what does the Constitution, the supreme authority over the governor, what does it allow him to do if he thinks there's a public safety emergency or the public welfare requires something? It says in Article 6, Section 19 of the Constitution that the governor may convene the legislature by proclamation whenever, in his opinion, the public safety or welfare shall require it. So there it is in black and white in the Constitution. If the governor, in his opinion, feels that the public safety is in jeopardy or that the public welfare requires new laws, new legislation, or the amendment of existing legislation, that's his remedy, is to call in the legislators, the voice of the people, our elected representatives. That is his option. So if why would our founding fathers of our state written that into the Constitution if the governor could just declare a state of emergency and do it all himself, be both the governor and the legislature? They wouldn't. There would be no reason for him to call the legislature into a special session. That is the remedy that our founding fathers of West Virginia put into our Constitution. And the governor has stated that this is the event of all of our lifetimes. That is how serious of a public safety emergency that we've been in for the last 9 months. So if he didn't call the legislature into session in response to that, not one time these past 9 months, when would he or any governor ever do it? The fact is they wouldn't, because it would challenge their own power, because the legislature, just with a simple majority, could end his state of emergency and and take over the power that he's wielding just by himself. Yeah, I mean, I've talked to many of the legislators. Talked to one yesterday, and I mean, yeah, the House of Delegates, I believe, far as I know, is still willing to come in and wants to come in and have a special session. As far as the Senate, I represented one of the senators and still am, but I have no idea why they are resistant to it. But I do think that there is going to be legislation introduced that is going to modify and clarify the emergency powers statute, which is necessary. But you could probably have other guests that have more inside information on that. That's about all I know. Well, we're going to be filing a state court challenge, and on behalf of 6 of those legislators and a sampling of small business owners who have been affected. And we're going to ask the state courts to declare that the governor has exceeded his constitutional powers under West Virginia state law. And that'll be filed first before the circuit court. It'll have to be in Kanawha County. And then I would presume that regardless of what happens, it's going to then go to the West Virginia Supreme Court. And that's their job ultimately to decide whether, what the Constitution says and interpret that compared to the facts on the ground here. The governor, what he's done the past 9 months, and give the answer as to whether he can do that or he can't do that. Sure, anytime.